Hi, I'm Shawn Armstrong. Welcome to Module 2 of the Biden crime family inside the modern American oligarchy. In this module, we're going to talk about whistleblowers, specifically IRS Criminal Investigation agents, and what they say happened inside the Hunter Biden investigation. We'll focus on who Gary Shapley and the other IRS whistleblower are, what they claim about deviations from standard procedure, how the Department of Justice handled the case, and why whistleblower protections in Section 6103 even matter. Let's start with Gary Shapley. Gary Shapley is a career IRS criminal investigation agent. He started at the IRS in the late 2000s and worked his way up to a supervisory special agent role inside the IRS CI, the part of the IRS that handles tax crimes and complex financial cases. In this role, he and his team follow the money, income, offshore accounts, shell companies, unreported income, and potential tax crimes. According to his testimony before Congress, he was directly involved in the Hunter Biden tax investigation, and he did something very rare for a federal agent. He came forward as a whistleblower. Alongside Shapley, there was a second IRS CI agent, another experienced investigator on the case, who also came forward backing up key parts of his story. So when we talk about the IRS whistleblowers in this course, we're mainly talking about Shapley and that second IRS case agent who both testified that this case was not handled normally. What they claim: deviations, slow walking, and preferential treatment. The whistleblowers describe several main problems with how the Hunter Biden case was handled. First, they say there were deviations from standard investigative procedures. Normally, in a serious tax and financial case, agents would move quickly on search warrants, conduct key witness interviews at the right time, preserve evidence before it disappears, and pursue all logical investigative steps without special exceptions for who the subject is. According to Shapley and the other agent, that did not happen here. They describe important interviews being delayed or blocked, and investigative steps they considered routine being shut down. Second, they talk about slow walking the case. Slow walking is their term, not a legal phrase. It means this: you don't cancel an investigation outright. You just drag your feet until statutes of limitations start to expire, and suddenly certain years and charges are no longer prosecutable. According to their testimony, deadlines were allowed to pass, and key years of potential tax liability were simply taken off the table by letting the clock run out. Third, they describe blocked search warrants and blocked investigative steps. They say that search warrants that would normally be considered obvious in a standard tax case were never approved or were shut down after internal disagreements and pressure from higher levels. That brings us to the phrase they use repeatedly: preferential treatment. In their view, Hunter Biden received treatment that regular citizens do not get. Delays, blocked warrants, missed deadlines, and investigative options taken off the table for reasons they saw as political, not legal. Now, to be clear, that's their claim based on their testimony. DOJ officials have their own explanations, and you'll see that tension play out in the documents. Let's talk about whistleblower protection statutes in plain language. In the federal government, a whistleblower is someone on the inside who comes forward to report violations of law, abuse of authority, gross mismanagement, or serious waste, especially when normal channels haven't fixed the problem. There are federal laws designed to protect these people from retaliation, things like demotion, firing, harassment, or being sidelined for telling the truth. For IRS agents, there are particularly strict rules about taxpayer information, which brings us to Section 6103 of the Internal Revenue Code. Section 6103 is the law that says IRS employees cannot just walk out and start sharing private tax returns with the public or the press. But 6103 also includes very specific exceptions. One of those exceptions allows for disclosures to congressional committees that have jurisdiction over tax matters. such as the House Ways and Means Committee under controlled procedures. That's how someone like Gary Shapley, who had lawful access to taxpayer information as an IRS CI supervisor, could become a whistleblower and still operate within the law. He didn't just leak to the military. He used a formal whistleblower channel to bring his concerns and underlying information to Congress for oversight. That's important. It shows he had real access to the underlying documents, and he was willing to put his career and reputation on the line by going under oath. Now, let's talk about the tension between IRS Criminal Investigation and DOJ prosecutors. In almost any big financial case, there's a built-in friction. IRS CI agents want to follow every lead, get every document, and build the strongest possible case. DOJ prosecutors decide what charges to bring, what venue to use, and how much risk they're willing to accept in front of a jury. According to the whistleblowers in the Hunter Biden case, that normal friction became something more serious. They describe investigative steps they believe were routine being blocked or delayed. Disagreements on search warrants, interviews, and charging decisions. And a feeling that DOJ leadership was more worried about the political fallout than about treating the case like any other defendant. In their telling, IRS CI wanted to move forward in a normal, aggressive tax case style. DOJ prosecutors, in their view, slowed things down, declined certain steps, and allowed key years to slip away through the statute of limitations. Now, DOJ says that's just prosecutorial discretion, choosing which cases to bring, which charges are strongest, and how to allocate resources. The whistleblowers say that this wasn't normal discretion. It was preferential treatment. That's the clash you'll see in the documents and transcripts. In this module, I've given you the overview, but in the book, I go much deeper into what these whistleblowers actually said. In the book, I give you long excerpts of their testimony and summarize the key deviations in one place so you can decide for yourself whether this looks like normal prosecutorial discretion or something else. You don't have to take my word for it. You can read their own words. Look at the timeline and decide whether this feels like a normal disagreement over tactics or something more like politically sensitive protection. So, to recap Module 2, you met Gary Shapley and the second IRS CI whistleblower and heard what they claim about the Hunter Biden investigation. You heard their allegations of deviations from standard procedures, slow walking, blocked search warrants, and preferential treatment. You got a basic explanation of whistleblower protection laws and why Section 6103 matters in letting insiders safely bring tax-related evidence to Congress. And you saw the alleged tension between IRS CI agents and DOJ prosecutors, between investigators who want to push forward and prosecutors who say, no, we're not going to do that in a politically sensitive case. In the next modules, we'll start tying this together with bank records, foreign payments, and the broader Biden family business network. As always, if you want the primary documents, bank memos, and full transcripts, they're printed and explained in the Biden crime family. I'll see you in Module 3.